It's said to be the cheapest, the most effective form of resolving disputes. It heals far better than litigation in a court, where friends are lost. But in alternative dispute resolution, friends are kept after the dispute is resolved. So why is it not as widespread in practice in the country as expected, especially after a law was passed in 2010 to cement it and to give it the blessing that it deserves? I have the best joining me this afternoon on the law. This is your legal light. It is your help law. We'll be right back to get into ADR, promoting it for all. You're welcome back. This is the law. It is your help law. It is your legal light. And this afternoon, discussing promoting ADR for all. My guests are Professor N.S. Swazi, who is at the University, California State University, Sacramento. And we also have Georgette Francois, who is chair of the Ghana Association of Certified Mediators and Arbitrators, GACMA. The IMC also joining is William Pedo, who is a member of the GACMA IMC. Ladies and gentlemen, good afternoon. Thank you so very much for making time to join us on the law.
It's a great pleasure to be here today.
Great.
Thank you.
Thank you.
Great. So we hear very often about ADR. And as far as we know, you are the association that sort of certifies mediators and arbitrators. When we say ADR, first of all, what is it?
I can take a stab at that. ADR could mean alternative dispute resolution. Also, in some literature, it may be referred to as appropriate dispute resolution. In some of my writings, I've also described it as African dispute resolution. But for the purpose of this conversation, some also have described it as available dispute resolution.
Oh, yeah.
All ADR. But for the purpose of our conversation, typically we refer to it as alternative dispute resolution, which basically suggests that in any disputing environment, there are multiple avenues or sources for people to try to seek resolution of their conflict. Some may define that also as an alternative to the formal legal system, litigation, for example. But we also argue in an expansive way that even within the formal legal system, you could have what the American legal scholar Frank Sander referred to as the multi-door courthouse. That even within that courthouse, the formal litigation process, people may come to the door to litigation, may go to the door to arbitration or mediation or other alternative dispute resolution processes. At the end of the day, the goal is for them to seek resolution of whatever the issues that may have brought them to the courthouse, or to the chief, or to whatever tribunal or community level where the parties deem fit, that is available, is accessible, is amenable to their circumstances and conditions, and they have trust and confidence that that particular process will be able to meet their expectations in terms of satisfaction. So that would be kind of an encompassing of alternative dispute resolution or appropriate dispute resolution.
Great. So I'm asking Georgette now, why should we be promoting ADR? We know that even in our courts, they appear to now give it a certain focus, so that even in the court in Ghana, there is a particular center that is set up for it, with a justice of the Supreme Court, heading the center, so that we call it the court-connected ADR. We know that very recently the rules of court have also been amended, where initially or formally it was only commercial matters that you will be allowed to attempt a pre-trial sort of resolution using ADR method. But now it has been open to every matter. So why would you say ADR is important, and why should it be given as much emphasis? I must admit to you first, when I discovered that Prof was in charge of the criminal justice department, I asked, what's he doing with ADR? And I found that he is also the founder of the center. Right.
Yes, ADR is important for several reasons. The first reason is because the traditional litigation forum, due to the rules of course and the procedures and lawyers filing all sorts of processes, there's a lot of time wasting. But ADR is faster, and ADR also helps the parties restore their relationships. Many a time, I mean, those of us who have practiced will come out of court having won your case, and you see your opponents, the disputants, very angry, shouting, and they start fighting outside the court, and sometimes you have to lead your clients away so that they don't get into a fight. But ADR has certain techniques and mechanisms which in the long run help to preserve the relationships between the parties. ADR is confidential and private, which is a plus because many litigants feel a little bit uncomfortable with going to stand in the witness box and testifying and being cross-examined. You can imagine.
And the court is open to the public.
Yes, everybody hearing you, and sometimes you are being, maybe there's a senior civil servant who is being cross-examined by a very young lawyer, sharp lawyer, who be putting it to you, I put it to you.
Embarrassing you.
Yes, and ADR is confidential. The discussion between the parties and the mediator stays within the mediation process in the mediation room, and the parties are not even allowed to go out and tell maybe their constituents what happened during the mediation process. The only thing they can say is the matter was settled, these are the terms of settlement. When a mediator is even subpoenaed to court to testify about the mediation, under our ADR Act rules, a mediator cannot divulge the contents or the discussions that happen during the mediation process. ADR is less expensive than litigation, and that, I say, is also a plus, especially in this time of recession. Those of us in private practice realize that our clients are not able to pay our fees as we demand, and they come with promises. But ADR is less expensive.
Okay.
It allows the parties room to become satisfied with the outcome. Many a time, parties in litigation win or are successful, and they are still not satisfied because ADR, the litigation doesn't address the emotional or psychological side of the problem.
One wins, one loses.
Yes, and ADR is a win-win process, whilst litigation is a win-lose process.
Interesting. So, William, share with us what are some of the methods, the processes. He says there are various methods and processes. Share with us some of these, and now help us to understand how we can access ADR. Because we know the courts are there. If I have an issue, I go to the court. If I have an issue and I don't want to go to the court and I want to go to ADR, how do I do that? So first of all, what are some of the methods? And then how can I access it? Then we'll come back to talk about the something special that you're about, as in the association.
Yes, thank you very much. There are so many different forms of ADR. First of all, when we talk about mediation, mediation is a process where a mediator sets himself before the parties. He is supposed to be as neutral as possible. And more often than not, the parties are able to get the opportunity to choose who the mediator should be. So the parties own the conflict. They have the conflict, so they know exactly how they feel. Their emotional approach to it is definitely established. The mediator only sits in to be able to guide them to settle their own dispute. It is not as in litigation where a lawyer will have to stand in for them and understand the conflict and be able to adjudicate on their behalf.
Right.
Other forms, arbitration. Arbitration is also another form of ADR, which goes a little bit beyond mediation, where lawyers and evidence is taken, at most of the sittings. Now, in being able to assess ADR, currently, as you rightly said, the courts have mandated that any case that comes to court must be referred to ADR. So the courts have the court-connected ADR. So all the courts have sections, ADR units, that cases are referred to the ADR. But it looks as if the Judicial Service is only managing that. GACMA right now is advocating for ADR at your doorstep. So we are training a lot of mediators in our communities so that at any point in time, any parties in conflict can access a mediation center in their own community other than going to the courts. So very soon, I believe in about a year or two, most communities will have ADR centers established in those places.
I don't know if you're seeking to emulate a particular country where we are told of how they spread ADR across the country in such a way that it brought such healing to the thousands of cases that they had to resolve because of massacre that occurred in that country. But Prof. Owazi, I want you to attempt to help us further to appreciate who is this ADR person I'm going to? Who gave him power or authority to sit in judgment or resolution of my case? If it's a judge, I know it is the state that is behind him.
Yes, this kind of goes back to what William was talking about in terms of the role of GACMA. It's an institution that is in place that over a period of time has received wide recognition. Training definitely is a critical part of that. Just like judges and lawyers go through training, we also require and expect that mediators go through the appropriate training. To really do an effective job of being a mediator, a basic training of about 40 hours with a series of continuing education in different aspects of mediation becomes quite critical. At the end of the day, also, we look to the ability of the mediator to be able to deliver. In other words, at the end of the day, when the parties that have come to the mediator would say, we felt satisfied, even if they didn't arrive at a full agreement, but that they felt that the mediator was able to listen to them and they felt heard, and that the issue that I had brought to the disputing table or session were fairly examined as a neutral, facilitator, in a way. A lot of mediation is about communication. In many instances, that's where parties oftentimes get stuck, is not being able to communicate. So if you're able to bring somebody who can help the parties to communicate. There is this what we call mediation magic or moment. When parties are coming into the room, they thought they would never be even able to sit in the same room, not even talk about agreeing on anything. But you go through that process after about an hour or 2 or 3, depending on who the mediator and the circumstances of the case may be, they're shaking hands or exchanging hugs and so on and so forth. So I think the training speaks to the importance of a good training and continuous training in terms of the mediator. And at the end of the day, is the ability of that mediator to skillfully be able to bring in the parties that they are working with to gain their confidence and trust that, yes, next time you can go to that person because they were able to help me resolve my issues.
Right. Yeah. And Francois, we know that the longest lasting, disputes, even in this country, have only been resolved successfully through ADR. Mm-hmm. The Dagbon crisis, for example. Mm-hmm. We know today that Dagbon crisis has a history of court processes, legislation, all of that couldn't resolve it. We know that in Boku, presently there are issues, and there is always the call for a mediation process or an ADR process. Court processes have not resolved the issue. So my question is, in these processes, we know that it is chiefs who lead the process. So they have a certain mandate. How easy is it for the people you train and certify to be able, and as you are seeking to do ADR at your doorstep, how will people accept? How do people accept those who are trained by you to do this job?
Let me first say that some of the people we've trained are chiefs.
Right.
And some of them are already embarking on establishing their ADR centers. Some are working with the courts, connected program, and so on. And we train ADR practitioners not only in arbitration and mediation, but the other processes like negotiation, med-ab, which is mediation, arbitration, in the same process where the mediator can move to arbitration, or ab-med, where the arbitrator finding, looking at the process, decides that now he wants to use mediation. We train them in conciliation, fact-finding, early neutral evaluation, and so many. There are over 20 ADR processes. Okay. In our ADR initiative, which we dubbed ADR at Your Doorstep, we want to get ADR's private service providers to engage in community entry, engage in community advocacy. We are not just going to ask them to establish a center and expect people to come to the center and use their services. Most of the people in the communities don't really understand the benefits of ADR. And the role of the centers is not only to provide service, but also to engage in a lot of ADR advocacy. And we are hoping that with that, people will begin to use this.
We know that in this month, you are embarking on a very special tour, and we understand that you are organizing it in collaboration with the California State University and the Center for African Peace and Conflict Resolution, which is founded and chaired by Professor Uwazi. So what is the nature of what you're seeking to do? You say ADR at your doorstep. What is the nature of what you're seeking to do, and why should we be excited about it? Maybe start with William.
Yes. This collaboration is one of the advocacy strategies that GACMA is putting in place. At one point, we referred to Professor Wazi as the grandfather of ADR in Ghana because it goes as far back as 1996 when it came into the country and introduced ADR. We collaborate with his outfit and we run these programs in order for the community to know about ADR. We need to do a lot of advocacy for people to know that ADR is really in Ghana at your doorstep, because you don't have to go to the court before you are referred to the ADR.
Right.
It's still the court, and you know,
that's even double expense. You already paid all
exactly.
Of the fees.
Then you go to ADR. You have to go to the courthouse. But we have realized that individuals are very uncomfortable going to the courthouse because you see lawyers and suits and all that. You know, it's quite intimidating from our research work. So we are trying to tell them that you can go for a mediating service outside the courthouse. So if your communities have the mediation centers established, you can easily walk into a place. We are training a lot of the mediators, and we are embarking on advocacy. That is why we have this relationship. As we go around, and the Criminal Justice Department, of which Professor Owazi heads, we have all the individuals visiting our detention camps, our Boston institutes, just to see how our judicial system runs. And then it gives us the opportunity also to tell Ghana that ADR, we are ready for ADR, and everybody can come on board, not necessarily go into court. Would offload the cases from the courts onto the ADR centers.
Right. Francois, we know that the court set aside a week, and then we say this is ADR week, and after that we all, slide back into litigation. How special is this particular approach that you are taking to introduce the system to the people, ADR at your doorstep?
Let me first commend the Judicial Service for their court-connected ADR system, because it's working.
That's right.
It's working. And let me also commend the Judicial Service for the ADR week. There are a lot of cases that find their way into the court system are not immediately referred to ADR because of our rules. As you know, you file your writ, they must serve the defendant will file a statement of appearance, statement of defense, issues, even there may be interlocutory procedures, injunctions, interim orders, and so on. By the time the case now comes for the directions where the issues are decided, where at that point is where the judge wants to refer the case to ADR. Sometimes it's 6 months, sometimes it's even 1 year, sometimes even with these interlocutory applications, simple case of interim maintenance, then the opposing side will file appeal. Then it has to go to Court of Appeal.
I can see
year.
I can see you are hesitant in stating that, because it is a fact that sometimes the processes delay so unduly. And in one case, the former Chief Justice, Georgina Wood, when she presided, I think in 2014 or 2016, when they concluded that case had come to its 40th year. A small land dispute of a family, small family, took 40 years. People had died, some had been substituted, judges had been changed. And she said, she described it as a parody of justice and the purpose, the need why we should focus on ADR. So you're right, sometimes it delays and a whole lot would have happened.
And,
right.
then additionally, there are a lot of people who find the whole court process uncomfortable. I know a lot of business people who say they will never go to court.
That's right.
They don't want to go to court. And ADR is the best option for them because they can go to the ADR service provider at their convenience. You don't have to be there at 9 and wait till 12 before your case is called. ADR is flexible. The disputants can choose the time and the venue they want. The disputants can even choose the mediator. I mean, sometimes the disputants will say they don't want this particular mediator or conciliator or arbitrator to handle their case. And the mediator is enjoined by the law to recuse himself from the case. And that is the power of the ADR processes. And that is why a lot of people prefer ADR. But let me also say that ADR is not a panacea for all cases.
Right.
There are certain cases, such as constitutional cases, interpretation of wills, interpretation of statutes, certain criminal cases involving felonies, which are serious cases, that ADR cannot help. ADR cannot be used to resolve those cases. But petty criminal cases like somebody using his car to break your trafficator light or your side mirror, those kind of things can be resolved.
Right. There's a debate why ADR should not be resorted to resolve environmental, matters as the law seeks to prohibit. But you are still here on the law. This is your help law. It is your legal light. And my guest this afternoon, as we discuss promoting ADR for all, and I'm sure you are enjoying it. We shall open the phone lines very soon for you to join us if you have any questions. My guest, Professor Ernest Suazi, who is with the California State University, Sacramento. Georgette Francois is chair of the GACMA IMC. GACMA is a Ghana Association of Certified Mediators and Arbitrators. And William Pitdo is also a member of the GACMA IMC, the Ghana Association of Certified Mediators and Arbitrators, IMC. We'll take a quick break. When we return, I have a question. The court gives a decision, and we know it is final and binding on the parties. If you disobey it, you will suffer the consequences. Is there that attraction in ADR? The law has an interesting point on that. We'll be right back. Welcome back. This is the law. It is your health law. It is your legal light. And we're talking about ADR, promoting ADR for all. And we're privileged to be hosting Professor Ernest Suazi, who is with the California State University, Sacramento, Georgette Francois, who is chair of the GACMA IMC, and William Pitdo, who is also a member of the GACMA IMC. Now, we will focus a bit more about ADR at your doorstep and the study tour that you are doing. But is ADR that attractive? And why should I resort to it? And I'm looking at the Alternative Dispute Resolution Act 2010, and it says in Section 82, status on effect of settlement agreement. It says where the parties agree that a settlement is binding, the settlement agreement has the same effect as if it is an arbitral award under Section 52. Interesting. So when you read Section 52, Section 52 says that effect of an award is a subject to the right of a party to set aside an award under Section 58 of this Act. An arbitration award is final and binding as between the parties and any person claiming through or under them. What does this mean? Yes.
I would defer to the legal experts.
The first section you read refers to mediation settlement agreement.
Okay.
And it just says that that mediation settlement agreement is final and binding as an arbitration settlement agreement in Section 58. what normally happens is during the opening statement, before the mediation process, the mediator must let the parties know that at the end of the process, when settlement is reached, they will sign a settlement agreement. Both parties will sign and the mediator will sign. Once it is signed, the settlement agreement is final and binding, just as an arbitration award. In the arbitration award, the arbitrator gives an award which is like a judgment. Now, the interesting thing is that when the mediation settlement agreement is signed, now a lawyer, independent lawyer, can take that mediation agreement to the court and file an application for the mediation agreement, settlement agreement, to be adopted as a judgment of the court. So this means that mediation is not actually as powerless as people think it is. And if you go to mediation...
So what you're talking about is not only referable to what the court initiates, but what the people you certify that you are training around the country arrive at, has the effect that you are talking about.
Has the effect. And then the most interesting aspect is that with the mediation terms of settlement and the arbitration award, because the parties initially agreed to enter the process and agreed to the terms, it means that they can't file an appeal. It is non-appealable, and it is final and binding, not like cases in court where you file at the circuit court or district court, then they appeal to high court, another appeal to court of appeal, then appeal to... This one, because the parties consented to the process and they consented to the terms of settlement, the inference is that they have agreed. There's nothing left again for them to appeal against. And this is one of the reasons why GACMA is encouraging community members to come and use our services, because it is faster. I have resolved a case within 3 hours, and the parties sign the terms of settlement. I make sure that they sign there and then. They don't go home and come and tell you they've changed their mind. They sign at the moment, and it's binding.
Within 3 hours?
Yes, it's binding. It's binding. They can't go away.
Right. So if you are just joining, then you are learning that the outcome of a mediation process, just like an arbitral process, is final and binding. It has that effect. So ADR is good. Yes, Prof.
I think Georgette has eloquently stipulated that, and especially in the legal context here, not only in terms of the parties willingly, knowingly, having been informed and making an informed decision or a consent to go through the mediation, but the studies oftentimes indicate that oftentimes they are very satisfied. That means, in fact, there is no need for them to continue.
That's right.
Right? They've already, whatever it is that they want to say, the mediation has provided them the opportunity to be able to do that. They feel satisfied, and they are more likely to recommend it to others and more likely to utilize that in the future, all things being equal. And that also speaks to the efficacy or effectiveness of that mediation process, which is in many instances, the appeal that you're talking about in many instances that people kind of felt there was something kind of left at that process, right? There was something that they really didn't quite get to speak to because of the rules of evidence and other admissibility kinds of issues, especially in a litigation process. But by and large, you're able to provide them that opportunity for to meet their psychological satisfaction as well as the substantive satisfaction. They really have no reason to complain about that.
This is because ADR is supposed to be interest-based and not right-based. What does that mean?
By and large, that basically when parties have come to the court or have come to any particular disputing arena, there is something that they need. And in many instances, it's not necessarily an issue of right. And I think Georgette has spoken again very well about that earlier on. We are not saying that there is no place for the litigation process. There is.
Right.
We are not saying that there is no room for lawyers. Even in the mediation, even in the ADR process, there is. And we definitely, and you've spoken very much in terms of commendation to former Chief Justice Georgina Wood, who's done an incredible job. I would also recognize Justice Nenea Megacha.
Correct.
On the same line. And of course, the work of GACMA. The Ghana Bar Association, I would also comment, that really worked very hard in the establishment of GACMA, that has become quite diverse in terms of the representation, of it. I think kind of a broad set of agencies or actors kind of made it, possible. But then again, interest-based basically means that the needs of the parties, when a conflict arises, are fully addressed. The underlying issues that in some instances may not be able to come out in a litigation process, as well as the presenting issues. What may have happened in many instances, there is a history to that particular grievance.
Right.
But when you go to the court may only be interested in terms of what happened today, not what happened yesterday.
What is this person's right against the other person's
or what happened the
rights?
previous day, and so on. And then and that's why oftentimes, especially in an adversarial system, in a common law system, which we have that experience also in the United States, the court oftentimes pose a question. What is the legal question?
Right.
That is actually the issue here. And that legal question oftentimes has to go to the issue of right. So even when the judgment is issued, it may resolve that legal question, but not necessarily resolve the conflict.
Okay.
And resolving that conflict means that you need to go back and look at what are the needs or interests of the parties that may have actually contributed to that particular dispute or conflict.
Right. And as we understand, this would not be your first time. William has already spoken to how far back you have been in the country to assist in the ADR process. And I have mentioned the fact that you are also responsible for the Center for Africa Peace and Conflict Resolution, California State University. Now, we understand that you're hosting, a team of professors, and they're coming from Sacramento, California, to conduct a study tour of Ghana's justice system. And firstly, you are looking at, the restorative Joy Oakland Youth California, which comprises 40 young professionals, international scholars, and ADR practitioners. And then you also have criminal justice students, about 25 students, and you also have the Africa House Sacramento group, about 10 professionals. What are you up to?
I know. Exactly. It's probably the longest stay in Ghana.
Yes.
Exactly. I guess it speaks to the interest, not just in terms of what Ghana has, but also the prospects for collaboration across the restorative justice. Oakland Youth Program is the other version of ADR, right? Especially looking at it in the criminal kinds of settings, especially pertaining to young people when they engage in infractions of one kind or the other. How can they be held accountable and also be able to restore both the victim and the offender, and be able to also provide some level of accountability in that process that would be sensitive both to the needs of the victim, the person that has been harmed, meet the needs of the person that committed the harm or the offender, and also restore peace in the community, because we know oftentimes they will come back. Even if you send them to prison, they'll come back into the same community, right? How we can come to terms in a more effective way of dealing with them. So part of this particular group of judges, as well as young people that are involved in this, in this endeavor, we have people that work with police commission, very diverse set of people. We're kind of interested in learning the things that have been going on in the ADR sphere, including community justice spheres, and the interactions between the formal legal system, the court and the police and the community. And And then my students will be joining afterwards, also looking at restorative justice, comparative justice in Ghana. And again, it's part of learning from one another. I believe that all cultures confront oftentimes the same set of issues. Though we may deal with them different ways, but if we learn from one another, we can even do better, in terms of our practices and draw some lessons that can helpfully provide some level of stability.
Right.
And provide that need for peace and prosperity and development that we all seek for.
William and Francois, you are hosting them. What's the nature, what's the form this is taking? How long is it going to take? And clearly, as he speaks, I can clearly see what benefits that we can get. But tell me again, I just want to hear, how does this benefit us?
Yeah. The first group, I must say, the first group is in the country currently, and they will be visiting the police headquarters in Dofsu to familiarize themselves with our detention, facilities, and speak with some of the inmates and all that. They will visit the Bostal Institute and see how the seniors corrective institutions have been put together. We are hoping that they are going to be visiting some prisons, some medium security prison, and be able to look at the female prisons and see what kind of facilities we have over there. It gives us the opportunity to see that, when members of the society are incarcerated, where they go to and how they are managed at those places. It also gives GACMA the opportunity to go to these areas so that when they come out and they come into the community, they will realize that there are other forms of alternative dispute resolution mechanisms that they can resort to.
Francois, that was going to be my question. Going to the prisons where people have been convicted and thrown in there, there's no opportunity of ADR processes there. So,
well, we have what we call victim-offender mediation.
Victim-offender mediation. Explain
yes. that. Where I think Prof gave some examples about where somebody has been suspected of a crime and has not yet been convicted, and it's allowed to meet with the victim. The accused is allowed to meet with the victim, and sometimes apology is offered, and the person begins to see his wrongdoing. Because, as Prof said, when especially young people are sent to prison facilities, they come out and they are worse. They come out and I think they lose hope, and so because they don't have any hope, they just want to misbehave to the hilt. And so victim-offender mediation gives them an opportunity to make a U-turn, to change, and to see their behavior in a different light.
So what's the impact? Yes, what's
we
the
don't
impact?
have
for
it.
Example,
we don't.
For example, somebody is anticipating that they are going to be convicted and sentenced to death.
Yeah.
They have committed murder. Somebody is expecting that they are going to be sentenced to about 25 years because they have committed, or 27 years because they have committed rape or defilement. When they see, and sort of what you're saying, they reconcile with the victim, the offender reconciles with the victim, it doesn't change their circumstance that they will suffer jail.
If I may weigh in, I'm sorry. Go ahead.
Oh, no, go ahead.
Because as I was mentioning, we'll kind of look at the ADR on a continuum. It doesn't necessarily. It can happen before or even without the criminal justice system. It can happen during any time of the criminal justice system. It can also happen after the criminal justice system has taken its own course. So we look at it in a very, very dynamic way.
Right.
It depends on what are their needs. I can speak to the victim offender mediation, or what we call in California victim offender dialogue, the project that we are working on now with the California Department of Corrections in California State Prison, Sacramento, where we have people that have been convicted of offenses, but the victims of their crimes have these questions that even after these people have been convicted and sent to prison 10, 20, 30, 40 years, the victims of their crimes have questions that only person who can answer the question will be the offender. So even though the criminal justice system has taken its own course, has prosecuted, has convicted, and the person is serving time in prison, the victim still feels that there is something that is kind of missing. And the offender at some point said, I really made a mistake. I want the opportunity for somebody to hear me that I have actually made a mistake. And that person I would really like to have to hear me is the person that I have harmed.
All right.
It doesn't mean that the person is going to get out of prison. Again, the person has been convicted. I can give an example of a now 37-year-old daughter whose father was killed when she was 2.5 years of age. The person that killed the father in 1998 serving time in prison. She wasn't quite told by her mother and her grandparents the circumstances. In fact, they told her that the father had gone somewhere. It wasn't until she was about 6 years of age when eventually the mother told her that the father actually had been killed. And she had wondered a question of why her father was killed. Different people, her mother, her grandparents didn't want to talk about it, or they gave different stories or accounts. The dad's siblings and friends gave different, until last year, 2022, 30-something years later on, she was able to say, I want to talk to the person that killed my father to find out why he did that. Because the accounts I'm getting or have received don't seem to make sense, right? And so we worked with her and the offender until eventually they had that meeting.
All right.
And it was quite transformational.
It's been so interesting. I've even lost a sense of time. But you can call us if you want to ask a question or two. You can call us. As always, the numbers are the numbers that you see advertised on the screen. But Francois, tell us more about this study tour as you began to do mutually. How beneficial is it?
Well, it gives, GACMA has a whole range of members, professionals, chiefs, students, and so many people who want to also interact with other professionals in another jurisdiction. So this is an opportunity for us to meet with Restorative Youth Group, meet with the students, and then meet with Africa House Sacramento and network, hold discussions, and also learn from them. As they are learning from us, we are also learning from them what happens. Because what Professor just said about the victim-offender mediation, the psychological aspect, it doesn't happen here. I mean, I know about plea bargaining and so on.
Which has just been introduced.
Yes, but this aspect of victim-offender, if we can introduce it, it will help. And perhaps through our interactions with the study tour, we will find a way of introducing it into legal space.
Right. Unfortunately, I'm told that we can't take calls. I allow time to run too quick. Yes, William.
Yes.
What else do we need to know?
We a young ADR in Ghana, as these groups come to visit us, we learn a lot. We want to familiarize ourselves with how ADR is taking place in other jurisdictions so that we can learn from them. And coming back to the issue of, the victim offender mediation, when you go to our prisons, you realize that most of the inmates, they have regretted so much for what sent them to prison. Some of them even cry. They wish they could be given the opportunity to explain to the victims what happened and how sorry they are. That's what leads to most of this mediation situations or activities that we are advocating for. And so it's a learning process for GACMA, it's a learning process for Ghana, and we believe that as we have this interaction, we'll take ADR in Ghana to the next level.
Right. Francois, I'm holding in my hand something that you have produced is the Ghana Association of Certified Mediators and Arbitrators, GACMA. This is Parties Guide to Mediation. And then there's another one, Mediators Guide. What exactly are you involved in, and how can people find you?
Okay, our office is opposite the Regal restaurant at Osu. We can let you have some numbers later on. We have a roster of mediators and arbitrators. Depending on the type of case, we can refer the case to a particular mediator. You know, I told you we have a whole range of people. We have surveyors, accountants, all sorts of people who are now mediators. We refer the case to them and they will resolve it. The parties need to be educated about the process so that they can understand it. And when they come, we always make sure that we give them, we answer questions. We can give you a number, you can call us, we'll answer any questions. And we welcome them to try, at least try ADR as a first option before you try litigation.
Okay. I want to have Prof give us his last words. And William, get ready and share with us some of your contacts, because there are people who are watching, listening now, who want to make contact to you with you immediately, or right from this point to see how they can get solutions to their problems without resort to the court process. Yes, Prof.
Yeah, it's been quite a great pleasure, and I think part of our goal here is to network. I have enjoyed over the years of our work and collaborations in Ghana. I hope we can learn more. Certainly, alternative dispute resolution has been a hallmark of that. I think there is still a lot that we can learn from one another, talking about the concept of victim offender mediation or restorative justice, which is a continuum of the ADR project. At the end of the day, we are seeking for justice. At the end of the day, we are looking for societies to grapple with issues, whether on the civil or the criminal front, in a way that will be able to bring about a level of peace and prosperity.
Right.
And we can learn from one another across the globe, and look forward to continue the dialogue and learning.
Justice, but not any ordinary form of justice. One that is lasting. One that promotes peace,
exactly.
as you said.
Exactly.
Very interesting.
Exactly.
Yes, Madame Francois, what can you say as we close?
Yes, GACMA offers not only skills-based training in ADR, we also offer training on how to establish, operate, and market your ADR center. Those two are our flagship programs. We offer training on customary arbitration and judicial, other judicial processes, also legal literacy.
You organize the training, or I can call you and say I want to be trained?
So we organize the training as and when we have a number of constituents.
Okay.
Constituents, yes.
Right. William, share with us how we can contact you, if it's mail, if it is...
yes, I have some numbers here that I'd like to put on the board. 0244 321 938.
Please say that again.
0244 321 938.
Thank you.
And then 024 356 6660.
Thank you very much. My guest this afternoon on the law, which is your health law, which is your legal light, have been Professor Ernest Tuazi, who is with the California State University, Sacramento, Georgette Francois, who is chair of the IMC of the Ghana Association of Certified Mediators and Arbitrators, GACMA, and William Pittsdoe also is a member of the GACMA IMC. I'm Samson Ladia-Yenini. Thank you so very much for your time and your company. See you again with an interesting edition of The Law. This is your health law. It is your legal light.